Good night to the viewers and listeners, and good night to the guests, Ruggles, Ferguson, Casey. Welcome to Legalize. We often hear of the court and of the legal system, and people with legal training often take it for granted. Everyone understands what is being spoken of. We hear terms as separation of powers, the Constitution, constitutional rights, statute law, common law, the judiciary, judges, magistrates, the High Court, the Court of Appeal, the Privy Council, the CCJ, mediation, the registry, the Judicial and Legal Services Commission, the Attorney General, attorneys at law, King's Counsel, General Legal Counsel, assizes, constitutional motions, civil claims, indictable offenses, summary offenses, the criminal court, civil court, contempt of court, judgments, verdicts, enforcement of judgments, claimant and defendant, defense and prosecution. We also often hear citizens complaining about delays in the court system, about high legal costs, about lawyers being crooked, judges being biased, inadequate sentences, draconian sentences. It is quite a lot. Lawyers spend 4 to 7 years studying to grasp some of this. But the law affects citizens in their everyday lives. Each citizen cannot be an expert, but each citizen must know the basics. Just like each citizen is not and cannot be a doctor, but we must understand basic body functions, basic hygiene, and basic health care in order to survive. Tonight, Ruggles, Ferguson, Casey has graciously agreed to share some of his over 30 years experience in the law to assist us in understanding some of the basics. The program is being sponsored by Jail Professional Solutions, JMFM, which is carrying the program out of Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Welcome, King's Counsel.
Yes, thank you. Good evening to you and good evening to your listeners and viewers. Very important topic for this evening. In fact, it's an area I always say that every single citizen should know. As you said, you don't need to be a lawyer, but the legal system is designed for the public. Judges and lawyers, magistrates, they all play a role in ultimately what is supposed to be a service to the public. And if the public does not understand what structure is there and how they can maneuver throughout the system to meet their needs, then you have access to justice issues. So congratulations on a good topic, well-chosen topic, and it's my pleasure to share whatever I can with respect to that area.
Yeah, so I guess we need to start by just basically, because we can only do the basics, as I say, people spend years just studying to be initiated into the practice of law. And of course, then it's really a career for many people. As attorneys practicing, there are people who are academics, professors, there are people who are researchers. So I guess we can only go into the basics. So when one hears of the legal system, the first thing you think about is the courts. The courts, is every court the same, or we have different types of courts? I think I
Okay.
hinted at the introduction and
Yes.
just go into that.
Yes. So when we talk about the court system, we talk about different levels. And first and foremost, there are the local courts, where you bring proceedings, you initiate proceedings. If you have a matter, you either bring it in the magistrate's court or in the high court. And these courts can be described as courts of first instance. In other words, you go there first, either as the magistrate's court or the high court. And then you have appellate courts, because you may be dissatisfied with the decision at first instance, and you may wish to appeal that decision. So our court system really has three levels. One level at first instance, and that's usually at the local level. And then you have the appellate level, and the appellate level has two levels. One, the Eastern Caribbean Supreme Court, and two, the Judicial Committee of the Privy Council. They are all appellate levels or appeal courts. So let's take Grenada. If we are using Grenada as an example, it is important when we talking structure and talking court system to understand first and foremost that Grenada is unique because it is part of the Eastern Caribbean Supreme Court. And the Eastern Caribbean Supreme Court is unique. And why? Because our court system, the Eastern Caribbean Supreme Court, encompasses all 9 countries that form the OECS grouping, the Organization of Eastern Caribbean States.
This diagram, Grenada.
Yeah, so you have Grenada, the Windward Islands, Grenada, St. Vincent, St. Lucia, Dominica, and let me deal with the independent countries first. These 4 from the Windward Islands, and then you have St. Kitts and Antigua, higher north, that are both independent countries. And then we have 3 overseas territories, British overseas territories. These British overseas territories have not yet gained or are not independent. They are overseas territories of Britain. They are not independent countries as the 6 countries we referred to earlier. And those 3 countries are Montserrat, British Virgin Islands, and Anguilla. So 6 independent states plus 3 British overseas territories. Those 9 countries make up the Eastern Caribbean Supreme Court. And so probably the simplest way to explain it is that you have the ECSC, the Eastern Caribbean Supreme Court, and there is a body responsible for appointing judges. Anyway, wherever you go, whichever country in the world, there's a body responsible for appointing judges. Judges don't appoint themselves. And in the Eastern Caribbean Supreme Court structure, the same entity that appoints judges in Grenada is the same entity that appoints judges in St. Vincent, St. Lucia, Dominica, St. Kitts, Antigua, Montserrat, Anguilla, and the BVI. And that entity is the Judicial and Legal Services Commission of the Eastern Caribbean Supreme Court. So we share resources as a court system among these 9 territories. And the Eastern Caribbean Supreme Court, JLSC, the Judicial and Legal Services Commission, is chaired by the Chief Justice of the ECSC, Eastern Caribbean Supreme Court. So, for example, our last Chief Justice, Dame Janice, who served for over 10 years before retirement, served close to 12 years. She retired in May this year. Dame Janice headed the Judicial and Legal Services Commission. And you have, on that commission, you have at least 2 judges, and you have the PSCs represented, the Public Service Commissions, and they do it on a rotating basis. So every 2 or 3 years, you change from the chairman, let's say, of Grenada to the chairman of St. Kitts to the chairman of St. Vincent, St. Lucia, etc. And that body is responsible for the appointment of judges. So these 9 countries have 1 Chief Justice, 1 Chief Justice, 1 Judicial and Legal Services Commission, 1 Court of Appeal that serves all 9 islands, and that 1 entity that appoints judges throughout the Eastern Caribbean and can transfer these judges to any of these islands. So you might be serving in BVI now, you can be transferred to St. Lucia or St. Vincent, Grenada, as the case may be.
And where is the headquarters of that court? Where is the headquarters based?
The ECSC headquarters is in St. Lucia. And so you have these 9 countries of the Eastern Caribbean, and just to contrast it, so one would get a better appreciation of the uniqueness of our system in the Eastern Caribbean. All the other courts have their own Court of Appeal, their own local courts, their own local Court of Appeal, their own local Judicial and Legal Services Commission, and their own local Chief Justice. So, for example,
sorry, go ahead, yes.
In Trinidad, you have the High Courts, you have the Magistrates Courts, and you have a Chief Justice, Ivor Archie, who is the Chief Justice of Trinidad and Tobago. He chairs the Judicial and Legal Services of Trinidad and Tobago. Any appointments made by the Judicial and Legal Services Commission of Trinidad and Tobago are appointments to serve Trinidad and Tobago only. Barbados has its own Chief Justice. It has its own High Court. It has its own Court of Appeal. And now the appeal to the final court is the Caribbean Court of Justice. The final court in Trinidad is the Judicial Committee of the Privy Council. So, for example, in a matter in Trinidad, it goes from the local courts of first instance, the High Court or Magistrates Court, and then it goes to the Court of Appeal of Trinidad and Tobago. That Court of Appeal only serves for matters originating in Trinidad and Tobago and dealt with by the High Court of Trinidad and Tobago. And if one is dissatisfied with the decision of the appeal court, one then goes to the Judicial and Legal to the Judicial Committee of the Privy Council. Unlike us now, the same Court of Appeal that sits for Grenada is the same Court of Appeal that sits in those 9 other islands. So you see, and that's unique in the world. In fact, it's a unique structure in the world. Many people are not conscious of it. and sometimes only when it is said now and then, that you really get that appreciation of 9 countries being served by a single court and a single chief justice. Jamaica is the same as Trinidad. Barbados is the same as Trinidad. Belize is the same as Trinidad. They have their local court system up to the first instance Court of Appeal.
Yes, so, but you spoke of if you have a matter, then you bring it there, but what's about in criminal matters where, in a sense, the person who is charged they don't go to the court voluntarily, they are brought to the court.
Right.
Yes.
Okay. So, well, first and foremost, when we at the local level, as far as our court system is concerned, at the local level, we have 2 sets of courts. We have the magistrates' court, and the magistrates' court is presided over by a magistrate. And then you have the high court, and the high court is presided over by a judge. Now, when we look at the law, we look at it in the context, broadly speaking, of criminal law and civil law. Civil law is further subdivided, but broadly speaking, we have criminal matters and we have civil matters. Criminal matters are matters where the objective of a criminal matter is to punish, and that's just broadly speaking. Somebody has committed an offense, the person is charged by the police, conduct an investigation, then the police charge that person for breach of the law, committing an offense, and in respect of criminal matters, we have, for example, a criminal code. We have a criminal code and we have a criminal procedure code. The criminal code sets out many of the criminal matters, but you have legislation where you have, like, for example, there was talk recently about the Firearms Act. So under various acts, the Firearms Act, the Drug Abuse and Prevention Act, people are charged under these acts. But the criminal code is a comprehensive code reflecting criminal offenses. That's on the one hand. And so in a criminal offense, generally, though you can have private criminal action, it is generally between the state and the individual. So somebody is charged for a criminal offense, let's say in the magistrate's court, and we'll look at summary matters and indictable matters. In the magistrate's court, so let's say an accused Y causes harm to a virtual complainant X. In a criminal matter in the magistrate's court, you won't find the matter is being brought by X against Y. The matter will be brought by the state through the commissioner of police. So it'll be commissioner of police versus Y for causing harm to X in breach of section 82 of the criminal code, or whatever is the relevant section. So X is a witness in the criminal trial. It's a police matter. It's a criminal offense alleged to have been convicted. The police charge, the virtual complainant or the victim, the person who suffers harm, is a witness in that matter. But let's contrast that. Same incident. Y injures X. And X decides now to bring a civil matter against Y for compensation. And broadly speaking, you bring civil matters, and I say very broadly speaking, so just for the purposes of illustration, you bring a civil matter now out of the same cause and harm, but the objective is to get compensation from Y for causing you harm. So that civil matter will be X versus Y. The criminal matter will be Commissioner of Police versus Y. So let's probably look at the magistrates court first, because we have two structures, local structures. We have the magistrates court. So anytime we say court, you could afford to say which one, magistrates court or high court, if we're speaking locally. In the magistrates court hears both criminal and civil matters, both criminal and civil matters. Now, for the criminal matters, there are certain limits as to the operation of the magistrates court. So let's look at the criminal matters. Criminal matters can be broadly subdivided into summary matters and indictable matters. So when you hear about a criminal matter, a question you ask, is it a summary matter or is it an indictable matter? What's the difference? Summary matters can be tried and determined in the magistrate's court. In other words, the magistrate has jurisdiction to hear and determine a summary matter in the magistrate's court.
Not by jurisdiction, speaking of the authority.
The authority of the magistrate.
Right.
Yes, the power. Right.
Okay.
So you bring it to conclusion there. It does not go anywhere else, unless, of course, the party wants the accused who, let's say, is found guilty, wants to appeal to the Court of Appeal.
Right.
But
so would it be correct to say that the summary matters are, generally speaking, less serious matters?
Less serious matters than the indictable matters.
Okay.
The indictable matters are the most serious ones. Now, with indictable matters, those matters also pass through the magistrate's court, but not for the purpose of trial. It's for the purpose of what you call a preliminary inquiry. And there are moves now, just as an aside, to do away with the preliminary inquiry process and replace it. But I just say that in passing. But generally, when an indictable matter goes before the magistrate's court, the purpose is not for the magistrate to conduct a trial, because the magistrate has no jurisdiction or authority to conduct trials of indictable offenses, only trials of summary offenses. So what happens then when an indictable matter goes before a magistrate? Just like the summary matter, the magistrate hears the witnesses are cross-examined. It actually mimics and reflects what happens with indictable matters or summary trials. All the witnesses give evidence. The difference, however, is that at the end of that hearing, of that preliminary inquiry, the magistrate is not finding that person guilty or not guilty. The magistrate can only find somebody guilty or not guilty when hearing a summary matter and conducting a trial. When hearing
what would the examples of summary matters? Just about
right. So summary matters, they start from the very basic. So for example, you have a list of harm offenses. Let's just take that line of offenses. You might just start off as simple assault. Then you have causing harm. Then you have causing grievous harm. Then you might have dangerous harm. You might have maiming, and maiming is when a limb is lost. Then you have attempted murder, and you have murder. In other words, different degrees of harm. Wounding, so you also have wounding as part of those general category of harm offenses. So let's say someone is charged with assault, simple assault. And with assault, it doesn't have to have the harm element. It's putting somebody in fear of imminent harm. So you go up close to the face of the person, as if you want to strike the person has fear of being struck, but you didn't touch that person. That could be an assault. So let's use the example of assault. A is charged by the police with assault. The victim is B. So on the so-and-so date, in town on Melville Street in the town of St. George, you did assault A contrary to Section X of the Criminal Code. When A, the accused, goes to court, the magistrate would read the charge to A, and then A pleads guilty or not guilty. That's the lingo for criminal matters. Guilty or not guilty. The comparable for civil matters in the magistrate's court, when a civil claim is read to you, is liable or not liable. So you don't use the same lingo for both. When you hear guilty or not guilty, that's a criminal matter. When you hear liable or not liable, that's a civil matter. So the magistrate reads the charge and invites the accused to plead. The accused might plead not guilty or guilty. If the accused pleads not guilty, then the magistrate conducts a trial. Witnesses are called, the virtual complainant himself or herself will give evidence, at the end of which, if the person is represented by a lawyer, the lawyer will make his submissions to say why this person should be found not guilty. The prosecution will have their bit to say, and I must say that just like in civil matters, you have two sides. In criminal matters, you have two sides. You have the prosecution bringing the matter, and in the magistrate's court, you have mostly police officers prosecuting, presenting the case to the court. And then you have defense counsel. So you have defense and prosecution. So when that charge is read, the person pleads not guilty, a trial is held. At the end of which, after hearing from prosecution and defense, the magistrate determines whether that person is guilty or not guilty.
Right, and that's for summary matters. So we talk about simple assault, lesser harm.
Causing harm, yeah, lesser harm, you have causing harm.
Insulting language.
Obscene language, threatening language.
Stealing a small sum of money.
Right.
So that's the magistrates deal with it.
Right. Those are summary matters.
Right, summary matters, and that's on the criminal side. And now, so what kind of civil matter will go to the magistrate rather than to the High Court?
What kind of civil matter?
Yes.
Yes. So it's civil matters now. You can bring a civil matter in the magistrate's court, or you can bring a civil matter in the High Court. What determines which court you bring it in? Now, I must say here that magistrates have a lot of work to do. They work hard. Conscientious magistrates work long hours because they have many more matters to deal with than the High Court, both criminally and civilly. Civil matters and criminal matters. Now, in the civil court, you have, broadly speaking, you have the law of tort. Those are civil wrongs. And under the law of tort, you might have you have things like defamation under the law of tort. And slander is the spoken word, libel is the written word. You can't bring a libel action in the magistrate's court, but you can bring a slander. You know, people slandering people, say things about people in the community. You can bring that. Once for the law of tort, the maximum damages you can get in the magistrate's court is $7,500 for tort. So like negligence, like accidents or personal injuries arising from civil claims. Once you are not claiming more than $7,500, you can bring it in the magistrate's court. Then you have a broad area, breach of contract. Like people enter into a contract, and most of these contracts are oral contracts. You know, people don't commit a lot of things to writing, and that's what causes the problem in the first case. But for contracts, the jurisdiction or authority of the magistrate is limited to $10,000. So if you have a contract, a breach of contract against, let's say, a builder was doing some work for you, and you contend that the builder has breached his contract, then what determines whether you bring it to the magistrate's court or you bring it to the high court is whether you're claiming $10,000, under $10,000, or if it's over $10,000. If it's $10,000 and under, magistrate's court. Over $10,000, high court. In the law of tort, 7,500 and under, magistrate's court. Over 7,500, high court. Now you also have other matters, and you have, for example, domestic violence matters. We have a Domestic Violence Act, which became a very powerful act in which even the owner of a house can be kept out of the house if the other party says, listen, this person has been violent to me. Domestic abuse, in other words. The magistrate's court has the power to order somebody being excluded for up to 3 years if you're making a permanent order. All those matters go to the magistrate's court. Domestic violence matters, they go to the magistrate's court. One of the rent restriction. All of these matters go to the magistrate's court. And in fact, when it goes to the magistrate's court, if you're owing rent, unlike some of these other matters where there is a limit on the amount a magistrate can award for rent restriction matters, magistrate can award thousands of dollars. Once you're owing rent there, then the amount that can be awarded is not restricted. So rent restriction matters go to the magistrate's court. You have maintenance matters. They all go to the magistrate's court. And you have lots of maintenance matters. You have, and maintenance matters, that's when a parent, usually the mother of the child, in the vast, overwhelming majority of cases, that's when the mother takes the father to court because the father is not paying maintenance for the child. And under our system, there is a duty to maintain a child. A child cannot maintain him or herself. And so under the law, you have a duty to maintain the child up to age 18 years. If you're not doing so, the mother or the parent, whoever's custody the child is in, it could be the father's custody too, but generally the mother brings it, and the court then can make an order that you pay a certain sum towards maintenance of that child for X period of time.
Yeah, Rob, just if you could just attend to some comments. Someone is asking about Belize. I think we will talk about the court system. Belize also have their own system.
Yes. So
So,
Belize in structure. In fact, Belize made some changes. Some changes recently too. It's slightly different from the OECS court in terms of structure. But you have in Belize now, it more reflects the OECS. Because in the OECS, you have a Chief Justice. And that Chief Justice is also the head of the Court of Appeal. In Belize, up to that's about 2-3 years ago, the Chief Justice was the Chief Justice of the administrative arm of the court, doing responsible for the judges. But when it comes to the Court of Appeal, there was a president of the Court of Appeal. So their Chief Justice didn't necessarily sit on the Court of Appeal. So there's a slightly different structure, though that has changed.
I think the question is really aimed at addressing whether Belize is separate from the OECS court system, or whether Belize has Trinidad, Guyana, Barbados. They have their own system. However it is, they have their own system.
Yes, the latter, yes.
The highest court is the Caribbean Court of Justice.
Caribbean Court of Justice. They joined the Caribbean Court, I think, in June 2010.
Right. So in terms of we come back to that. Somebody's also asking Dickma, can summary and Supreme Court matters be settled outside of court? Maybe we come back to that question.
Yes.
It depends on whether it's criminal or civil.
Yes. Yes.
We come back to that maybe in terms of when we speak about the issue of mediation, for example. In the criminal matters, I know it is really the state matter. So strictly speaking, it's a matter for the state to determine.
Right. Yes, but there could be settlement of criminal matters. And just let me make the point. Anytime the word summary matter is used, is a criminal matter. Yeah. Anytime the word summary, anytime you see summary. So for example, the laws may not say that this matter be tried in the High Court or the Magistrates Court. It will be styled like if you commit an offense, or X is an offense, if you do X, it is an offense. And upon summary conviction, when you see those words, summary conviction, you know a summary conviction can only take place in the Magistrates Court. So, but you can settle criminal matters, and sometimes the court encourages it, but it cannot be done without the consent of the prosecution. The prosecution may agree, listen, this is a matter to settle, let's have discussions and arrive at the settlement, and the court at times encourages it. However, you might have those for like harm cases, but not sexual offenses. Sexual offenses is a no-no as far as settlement is concerned. The court does not embrace it, neither does the prosecution.
Right, and extreme care has to be taken by defendants, so as to not run the risk of being accused of interfering with the process of seeking to pervert the course of justice or whatever. Jomo is saying the limit is 15,000. I think that's a limit for magisterial civil claims.
But it depends on what kind of civil claim, because so as I said, the law of tort.
Yes.
And greetings, Jomo. Nice to hear you. If it's tort, it's 7.5. If it's contract, it's 10. So I don't know if their system, for example, has across the board, or whether it's tort or contract is 15.
Yeah, and almost following on what Jomo is saying, Jackie McKenzie is saying, having small claims in the magistrate court must clog up the system. Are there different tracks and judges here in these matters? If not, the High Court needs a small claims division.
Well, so the magistrates court is usually referred to as the small claims court. That's where you bring the lower claims, what is described as small claims. But you have a lot of those matters as more and more people become conscious of rights, and they go to the court, they bring matters, the system gets clogged up. And one of the areas, for example, of debates, and it was contemplated years ago, and it was actually set up, and there was a change of government. But the setting up of a family court, a family court to deal with all family matters, And you had, when that was proposed, you have the president of a family court. So, for example, in St. Vincent, there is a family court. I trust that it is still operational, but that court looks at family matters. In Grenada, you have a traffic court. Most of the matters, well, you have a traffic court in St. George's, and most of the traffic matters are heard in that court. Because more and more, the numbers grow, and the magistrates court gets clogged up.
Well, as we speak about a prolific area, and I know there are several people who are following the program who will want me to ask this. A prolific area is really deal with possessory title, land matters. And we don't have a separate court or a separate system to deal with that. Maybe that's sometimes clogging up the system. Because I remember a few years ago, you had several hundreds of these matters to deal with, and that is an area that probably needs attention.
Yes.
Just sorry, okay, you want to comment on that?
And maybe as you make the point of possessory title, that you may have land matters being heard in the magistrate's court, like trespass to land, people claiming damages for trespass. But if that matter relates to title to the land and ownership of the land, in other words, in order to settle the matter, one has to determine who is the owner of the land. Then the magistrate does not have jurisdiction or authority to deal with matters of title or settle matters of title. Those matters then will have to go to the High Court. So that's one of the areas with possession of land, because most times people, a landowner might say, listen, you're on my land, you're trespassing on my land, I give you a notice to go, you have refused to leave, I'm now going to the court for an order for possession. When you go for the order of possession, or the person raises a defense and says, listen, I have been on this land for X number of years, I've been treating it as my own, and in circumstances as that, because they can be proven by the magistrate, because some people just say, I just say it as part of the of what they because they want to rely on it as a defense. But once it's a genuine defense raised, then that has to be determined in the High Court.
Yeah, but I was more referring to the scores, maybe hundreds of uncontested possessory title claims, which really arose since less than 10 years. And I know there are many of these matters taking up the time of the court. So, okay, so we have the magistrate court, criminal division, civil division. Well, not really division, but they have a magistrate court, and depending on the nature of the matter, the magistrate who sits as a civil judge or as a criminal judge. I mean, the magistrate as a civil magistrate or criminal magistrate. And at the court, we have the same area. So you have a matter before the court, and you are magistrate or court or high court, you get a decision and you are not satisfied with the decision, then you go to the Court of Appeal.
You go to the Court of Appeal, yes.
And what's the difference now between the level of the Court of Appeal and what you call the first instance, the High Court or the magistrate court?
Right. So the Magistrates Court and the High Court, as I said, those two courts are referred to as the courts of first instance. In other words, that's where you go originally to have your matter determined. Now, the court may have determined the matter and you are dissatisfied. Once upon a time, when it was a magisterial matter, you had to appeal to the High Court. That is no longer so for many, many years. If you are dissatisfied with a magisterial decision, you appeal to the Court of Appeal. If you are dissatisfied with a High Court decision, you appeal to the Court of Appeal. One of the immediate differences is that in the Magistrates Court sits one magistrate. In the High Court of first instance sits one High Court judge. When you appeal a matter and it goes to the appeal court, then that is determined by 3 judges. Ultimately, 3 judges. In other words, you have 3 minds looking at something that one mind looked at. And as a matter of fact, if you illustrate the point even further, when you go to the highest court, in our case, the Judicial Committee of the Privy Council, 5 judges sit. Or if you have moved from the Judicial Committee of the Privy Council to the Caribbean Court of Justice, in its appellate jurisdiction, 5 judges sit. So you have 1, 3, 5. 1 at first instance, 3 at the first level Court of Appeal, and 5 at the final level Court of Appeal. So you have additional minds being brought to bear on it. So you have those numbers. In our case, we have to appeal to the Eastern Caribbean Supreme Court. That's where the appeal has to be lodged with the Eastern Caribbean Supreme Court, and that court sits in Grenada every quarter. So that's 3 times a year. It's what you call an itinerant court. It goes from country to country. Well, since COVID, it has not been going, but it has been sitting virtually. It came here once or twice, few times. But it has been sitting virtually since COVID. And it sits for Grenada. Over 3 times a year. One of the advantages, though, is that if you have an urgent matter, because it's the same court we have sharing with St. Lucia, or sharing with BVI, or sharing with St. Vincent and the Grenadines, outside of your timetable schedule, you can ask the court to hear your matter in another jurisdiction. So, for example, we have had matters in Grenada. Those matters were a fair measure of urgency, and they were held outside. I remember we did 1 or 2 in St. Vincent. We did in St. Lucia. There was one for BVI, because it's the same court. It's the same judges appointed by the same Judicial and Legal Services Commission, chaired by that same single Chief Justice that serves all 9 islands.
Mm-hmm. Now, just as we on the structure, how the Privy Council, which is the final court, what is, in our case, what's its relationship to the Eastern Caribbean Supreme Court, our court system?
Well, its relationship, basically, is hearing the appeal. In other words, there's the Court of Appeal rules against X. X is dissatisfied with the ruling of the Court of Appeal. X appeals to the Privy Council, and you usually have to get leave. There are some matters, like constitutional matters, where leave is automatic, but you still have to go through a procedure through the Court of Appeal to get leave or permission. So you have to apply there and get it, or there's another route where you can ask the Privy Council for special leave. But once you have special leave, then you argue your case before the Privy Council, and the Privy Council rules on it. Most times people go up to London to argue their case, the Privy Council rules, and that's the end of the matter and the end of the relationship, I must say. And that's why I take the opportunity always when making those kinds of references is that when you contrast that with a Caribbean Court of Justice that provides training for judges, that provides administrative support.
That's what I wanted to get at. If they have any function. So, for example, the Chief Justice of our court has administrative functions, hence the Judicial and Legal Services Commission appoints judges and gets supervised judges and so on and so forth. The Privy Council doesn't play that role with regard to our court system.
Not at all.
Right.
In other words, the same thing we complained about 30 years ago is the same thing we complain about today. Again, that's not the business of the Privy Council. And why? Because the Privy Council are judges paid by the United Kingdom. I always say one of these days, the taxpayers of the United Kingdom, I really catch up on this and they say, hey, why are we paying for judges for these folks? And they are judges, usually appointed to the Supreme Court of the United Kingdom. We have absolutely no say in who is appointed to the Privy Council. They determine who will hear a matter. So they are judges of the Supreme Court most of the time. And they might even occasionally bring in somebody from the Court of Appeal to hear a matter. When you contrast that to the Caribbean Court of Justice, those judges are appointed by a Judicial and Legal Services Commission of the local court. They have to go through a process of application. They have to go through a process of screening. And the Judicial and Legal Services Commission ultimately determines.
But supposedly the same thing happens in the UK with the appointment of judges, not so?
Yes, but I'm saying that that's under the UK system, right? They appoint a judge and they hear our cases. In the region, the Judicial and Legal Services Commission is comprised of nominees from several stakeholder groups in the law. It's not just people being arbitrarily appointed. You have, for example, the Chief Justices of the region represented the University of the West Indies Faculty of Law, the law schools. Sorry?
That's regarding the CCJ.
Yeah, that's why the bar associations, all have stakeholders.
The CCJ, but I wanted to ask you before that. Recently, the former Chief Justice you spoke of earlier actually was appointed to the Privy Council.
Yes, she was appointed.
Yeah.
Right. What I'm not too clear on, because there is the Privy Council and there's the Judicial Committee of the Privy Council.
Yeah.
What I suspect, because I've not seen any clear statement on the Privy Council, because you know there's a Privy Council there, apart from the Judicial Committee.
Yes.
A Privy Council that advises the King, His Majesty. So the Judicial Committee advises on judicial matters. The others, Privy Council advises on political matters. But I hesitate to say that it will be any other thing than the Judicial Committee of the Privy Council, because at one time we had Caribbean people, not many. I remember Sir Vincent Flosack I believe, actually sat on a matter in the Privy Council, Judicial Committee, and you had that former Chief Justice of Jamaica who sat on the Judicial Committee.
And judges from other Commonwealth countries.
Yes.
Okay. But we have the unique situation now where you have the OECS Court, the Supreme Court, with the Chief Justice, and the Court of Appeal, the Chief Justice being, in effect, the head of the Court of Appeal. But you also have, in the case of Dominica and now St. Lucia, they having different quote-unquote highest courts to the other islands. How that works?
Well, yes, Dominica and St. Lucia have both joined the appellate jurisdiction of the CCJ. And I say appellate jurisdiction because, and when we say jurisdiction, we mean, as we said earlier, power, authority over something. So there are two jurisdictions in the Caribbean Court of Justice. Unlike the Privy Council, it's a straight appeal court. But the Caribbean Court of Justice has two jurisdictions. One is referred to as the original jurisdiction of the court, and the other is referred to as the appellate jurisdiction of the court. We are all part of the original jurisdiction of the court. What the original jurisdiction does, it hears and determines matters that fall under the revised treaty of Chaguaramas and dealing with, for example, free movement of goods, of services, of labor, etc. So anything that, so trade like matters, trade type matters, the original jurisdiction deals with that. But it's the same set of judges. It's not different judges. You have judges of the CCJ, they will sit in the original jurisdiction, or they'll sit in the appellate jurisdiction. No. We have had instances, and there was a case out of Trinidad and Tobago that dealt with the death penalty, and where you have had instances where the CCJ has departed from the reasoning of the Privy Council, where both have disagreed with each other, and what you will have in a situation like that is that whatever is the highest court for Dominica and St. Lucia, because you have the principle of stare decisis. In other words, whatever a highest court rule you have to follow. Put simply, and therefore, we have to follow what is the final decision of the Privy Council. Dominica and St. Lucia have to follow what is a final decision of the CCJ. What is their reasoning on it? If it differs from the Privy Council, the CCJ reasoning prevails once the CCJ is the highest court, and vice versa. Now, that can create an unhealthy situation, really, which I think is the point you're driving at. Because right now, when we have one final court, all of these countries...
Just hold the point. I just want to, at this time, just recognize Gem FM for carrying the program. Thanks to Gem FM, and also TAO for sponsoring this program. And I think we have an advert from TAO.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
And also, I just want to refer to some comments there. Martin Strong is asking, where does Consumer Affairs? I guess he's asking matters under the Consumer Protection Act. Where does such matters, which court deals with such matters? But I think the act has its own system. In fact, there's supposed to be a Consumer Affairs Tribunal, but you can still go to court, and it will depend on the nature of the matter.
Yes.
Jesus Keith said, curious, can a landowner take a utility company to court for passing water lines or planting electricity poles without the owner's permission, even if the land is not occupied at the time of the infrastructure being laid? Well, I think that's a separate issue. Maybe it could be dealt with separately, because I don't want us to go off the issue of the structure. But he asks, and which court is most applicable in this case, if so? So that will be
most likely, and that would be the High Court, because you'll need some injunction, some order to get it off the property. So that will be High Court.
So Martin clarified, where does Consumer Affairs issues fit in relation to standards? Someone who wishes to sue for a defective product under warranty, as the case may be. Well, as I said, you have the Consumer Protection Act, and it addresses that, but it does not oust the jurisdiction of the court as such.
Yes. And you find more and more tribunals being set up. So it's the court would not be clogged. So, for example, in some countries, you have employment tribunals. We don't have any here, but we have the system, conciliation, mediation, arbitration through the Labor Department for many matters. You have in Trinidad and Antigua, both Trinidad and Antigua have industrial courts. And so all matters dealing with the employer and employee go to the industrial court. They are the only two countries in the region with full-blown industrial courts. So the more and more, as you have an increased number of matters coming before the court, and the court having lacked or lacking the capacity to hear all these matters, you have specialist tribunals in many cases dealing with them. And the specialist tribunals are more able or better able to deal with them because they require specialist knowledge, to put it that way. But as you said, in most instances, the jurisdiction or the authority of the court is not ousted. It's just that you need to exhaust the procedures that are available at the level of the act or the tribunal, as the case may be. And if all fails, then the court could be there as a final resort. But it depends on the law and what the law says, the law that creates these tribunals.
Right. And just earlier when you mentioned about the family court and family matters maintenance, someone was asking Nick Mark, what if the mother isn't allowing the child to see or spend time with the father, but she collects the money at the court? What can be done legally?
Yes.
In this?
Well, yes. So the father can make sure, because the father is entitled to access to the child. Many times you have a mixing up of concepts. So when you're dealing with children, the probably the three major concepts are: one, access; two, custody; and three, maintenance. Custody is who has care and control of the child. Who does the child stay with, and ultimately can take decisions or primary responsibility for decisions for the child. But usually custody relates to a physical thing. You can have joint custody, or you can have one parent having custody. So that's one thing. Maintenance.
Rex, I don't want us to spend much time on
Right.
that. We
Yes.
have a separate
Yes.
program.
Well, that's true. That's true. Yes. Yes.
Yeah,
That's true.
but I just want to comment. Jacqueline Mackenzie saying announcement on UK government site says Dave Janice Pereira, Chief Justice of the Eastern Caribbean Supreme Court, is appointed as a Privy Councillor, which will include sitting on the JC, that's a Judicial Committee. This suggests a wider role, specialist courts, and the way to go. That's what Jackie's also saying. Grenada needs a family court, land court, and small claims court, and leave the magistrates to deal with criminal matters so that justice is obtained in a timely way. Cyrus Griffith is asking, where does the industrial court fall in relation to the court system with regard to your presentation on legal system? I think you dealt with that. And how does Pratt and Morgan case affect? What is the final decision regarding the criminal matter? And Jomo is asking if you have any views on the second short-term appointment of Justice Mary Machel as the Chief Justice.
Mm-hmm. Yes. Well, yes. Well, in relation to the last, Mario Michel is the most senior judge on the appeal court. And what you usually have is when the Chief Justice is on vacation, for example, the most senior judge acts. So he has been acting, and once it's an acting appointment, because of his seniority, then he will continue to act. I'm not too sure of the details. As far as what I know is that there was some consideration and there was some process and procedure to appoint a permanent Chief Justice. He has been appointed and reappointed on one occasion, 2 or 3 occasions to act. So besides that, I can't really comment on it. Safe to say that it is not unusual for him to act. And in fact, it is not, he is the person next in line because of his seniority. And therefore, once it's an acting appointment, the most senior judge acts. Secondly,
sorry, I was saying, I think the difference that is being pointed to now is that it's not a case where the Chief Justice is on vacation. It's a case where there is no Chief Justice.
Right. So when there is no Chief Justice, then the most senior judge acts. Whether the Chief Justice is on vacation, whether the Chief Justice has retired, once it's an acting appointment, the most senior judge acts.
But I think Joe's point is that they need to fill the role
of
of
course. Well, yes, of course. But again, it is not always easy to fill those positions. So, for example, there are ads out right now for the position of President of the Caribbean Court of Justice, because Justice Saunders will be retiring sometime in July next year. Under that system, you have 7 years. He was appointed in July 2018. He was appointed. Those years have flown by. So at the level of the CCJ, either he reached the age of 72 or 7 years, whichever is the sooner. So in that case, he has to retire because he by that time would have served by July next year, would have served 7 years in the position. So I can't comment much more on that, except that I know a process was in train. I can't comment with any authority as to what has happened as far as that process is concerned. In relation to the other questions, there was one on Pratt and Morgan. And Pratt and Morgan really deals with the after 5 years, you cannot. That was a 1999 decision of the Privy Council thereabout, where it says, listen, after 5 years, it violates the Constitution. It will amount to cruel and inhuman punishment if you carry out the death penalty. So that was Pratt and Morgan. It hasn't really affected the court system per se, but the interpretation of the law as to how you go about dealing with death penalty cases. And the first question you raised?
About the industrial.
Industrial court. The link is that we don't have an industrial court, but where there are industrial courts, and certainly in Antigua, where there's an industrial court in the OECS, if you are dissatisfied with the decision of the industrial court, you go to the Court of Appeal. So that's the structure. You have magistrates court, you have high court, and you have industrial court. We don't have an industrial court. However, in the arbitration process we have under the Labor Department, you go first, Labor Commissioner for Conciliation. If that doesn't work out, you go to the Minister, mediation, and at the highest level, you go for arbitration, and you appoint those tribunals on a case-by-case basis. And so the decision of the arbitration tribunal, unlike conciliation and unlike mediation, the arbitration tribunal's decision is binding. However, you can appeal points of law to the High Court. That is where any structural thing relates to arbitration. You appeal, but only on points of law, not on fact.
Okay, so we therefore the straight court system, the magistrate, High Court, Court of Appeal, Privy Council, or Magistrate, High Court, Court of Appeal, CCJ. Now, we hear a lot about mediation. Where that fits in?
Mediation is part of the High Court system. You have formally, it's part of the High Court structure. So you have court-connected mediation. And so usually you have different stages in a High Court matter, in a High Court civil matter. So I usually refer to them, to simplify, you have the pleading stage where the claim is made and then the defendant puts in his defense, the claimant puts in a reply to the defense, and all that constitutes the stories of the respective parties. What this matter is all about, what is the facts surrounding this case. And then it goes to the case management stage, and you have another stage called the pre-trial stage and trial stage. Mediation comes in a lot at the case management stage, where parties are encouraged to look at mediation as a way of resolving the matter out of court. But it's connected with the court because the mediators are trained by the court, and the court-connected mediators are listed and approved of by the court. So when a matter is sent to mediation, then parties, there's a mediator appointed, parties try to resolve it. You have, when you're going into a mediation, you have what you call a confidentiality agreement and a mediation agreement to mediate, because what you say in mediation cannot be used in court. The judge is not supposed to know what went on in mediation. The judge is not supposed to know who caused mediation to fail. And all of that is designed to let parties talk openly so that you can't use what somebody says in mediation in a trial. So, for example, if somebody says the facts are ABC in the mediation, and that same person goes to, the matter is not resolved, it goes to trial, and that same person says, the facts are X, Y, Z, then you can't say, the other party can't say, well, listen, let's call the mediator as a witness, because look, he's lying. He says the facts were he said the facts were ABC, now he's saying it's X, Y, Z. So it's a confidential process. But the beauty of the process is that it includes everybody. It allows the parties to vent, to engage, and possibly reach a settlement. If a settlement is reached, then an agreement is signed by the parties and approved ultimately by the court, unless there is some compelling reason and some unlawful aspect of it that the court would not approve it. But invariably, it is approved by the court, and that matter that agreement then becomes the court order. Just as if the matter had gone to trial and the judge had come to the same conclusion as contained in the order. Meaning that a mediation agreement turned court order is as enforceable as a matter that goes to trial and the judge makes a ruling on it. Same thing. You can enforce it both ways. But what it does, it gives the parties an opportunity to settle. And then in Grenada, there's a high rate of settlement.
And also the freedom to, because you may be able to see things in the mediation that the rules of evidence and so will not allow you to say in the courts. Because
right.
Sometimes the real story behind many of these matters, the rules of evidence may not allow them, the real story, to come out in the courts.
Right, yes.
Yeah? But when you go to mediation, you realize that the real story may be something that happened about since the people are children. There's the real story.
Yes, you have that.
The real cause, but yes, so it's a process that is encouraged and it's part of our whole system.
Very much encouraged, yes.
So, Jason, what is more enticing and substantial in mediation is the lawyers will take a back seat and allow the parties involved to express themselves.
Yes, that is important. That is important. In fact, yes, as I explain it, usually explain it. In mediation, the parties talk more, and lawyers talk less. In fact, where the lawyers are crucial is for guidance to guide the parties to clarify things with the mediator, but the mediator allows parties and pushes parties to talk. And in a trial, though, the lawyers talk more and the parties talk less. Mm-hmm. So you want a system where parties can vent and engage and go back and forth. It may not resolve at the first go, but it might be adjourned and then you have a second go and even a third go and a fourth go in some cases, and it's eventually resolved.
Mm-hmm. Okay, so I want you, Ruggles, there was a recent case that you know quite well. And I think that case, in a sense, brings to... You want a minute?
Yes, let me just take off my camera because I'm looking at that battery going on. Let me just plug the phone because I'm using the phone. I had a problem when I was signing on the computer. So if you just give me one, just let me take on the camera and plug on before I lose power.
While you
can do an ad in the meantime.
While we do that, we recognize once again GMFM and Tau for the support for this program. Thank you, GMFM. Thank you, Tau, for supporting this program. The program is also sponsored in part by GEL Professional Solutions, Inc.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay, yes, I'm hoping it will improve. Yes, so we can continue.
Yes. The recent case of Case Simon versus the Attorney General, I think that case probably could illustrate several of the matters that we'll be raising here tonight in terms of the court structure and how the court operates. I know it's still a first instance decision, but if you can tell us a little about it, and we can just examine
Yes.
that kind of drill down on how it relates to what we'll be discussing here tonight.
Okay, well, the case, Simon, for the purpose of this discussion, really speaks to the different kinds of matters that can come before the court. So we spoke of criminal matters, broadly divided into summary and indictable matters, and we spoke of civil matters. And civil matters, for the purpose of distinguishing them and putting them into two broad categories, can be described as matters that are not criminal. They are civil, but under under civil matters, you may have like family matters, you have land matters, you have different categories of matters. But the Case Simon matter is really what you describe as a constitutional matter. A constitutional matter. And that even distinguishes it again from the regular civil matter. It's a constitutional matter where Case Simon was an employee of the state. In fact, she worked at the Attorney General's chambers. She was first on a 2-year contract from October or thereabouts 2019. For 2 years, her contract ended in October 2021, and then it was renewed for a further 2 years to 2023. So she was one of the attorneys in the AG's chambers. She was one evening, she received a letter essentially saying that her appointment, her services were no longer required, and that she would get 1 month's pay under the contract. And basically, just to fast forward a bit, our contention was that, well, first of all, she could not be dismissed the way she was dismissed. She was dismissed by the permanent secretary at the time in October. That was October 2023. Yes, she was dismissed by the permanent secretary. We said the permanent secretary did not have authority to, as a legal officer, to dismiss her because Case Simon being the legal officer, and that legal officers are protected by Section 88 of the Constitution. There's a special section that protects legal officers. That includes registrars of the court. They are appointed by the Judicial and Legal Services Commission.
All right, so the same
legal
Judicial and
officers.
Legal Services Commission that we were speaking about earlier.
Precisely, yes.
Okay, good. So
Right.
It relates to that. The appointment is by the Judicial and Legal Services.
Legal Services Commission. Right. And
she was aggrieved, and then she went to the High Court.
Right.
She did not have to go to the magistrate.
Right. So that was a High Court matter because
Why was it a High Court matter?
because
But
the magistrates court does not have jurisdiction authority to hear constitutional claims.
okay.
Those are for the High Court exclusively. So, and essentially, so as a legal officer and as someone who was appointed by the Judicial and Legal Services Commission, our contention was that the uh, Governor General was appointed on the advice of the Judicial and Legal Services Commission. So that's how it goes with the appointment of legal officers. The
Okay.
JLSC advises the Governor General. The Governor General issues the instruments of appointment. In relation to case Simon, so that was done. The state accepted about January, February 2024 that the PS could not dismiss her. So what the PS did was to withdraw the dismissal letter, and she was paid now for up to October to January or February. But on the same day the letter was withdrawn, then she received another letter, this time from the Governor General terminating her services on the advice of the Judicial and Legal Services Commission. So he said, hey,
Yeah,
you
sorry.
can't. So in their mind, they were correcting the defect of the first dismissal. And we contended, no, you can't just dismiss her so without any reason. Her, even though she had a contract, and I think the essence of the case was this: even though you have a signed contract, that contract is subject to the Constitution. And she had a 2-year contract. If you have to dismiss her, there must be good reason for dismissing her before the contract expires. So in this case, there was an attempt to dismiss her 1 year before the contract expired. We say that contract is subject to the Constitution, the relevant provision being Section 88 of the Constitution, and your dismissal must be for cause of a legal officer, must be for cause. And therefore, you can't just send a letter to her telling her she's dismissed. If there were no issues with her, there were no complaints about her performance, and therefore, there was no basis for just dismissing her before the natural term of the contract expired. If you want to dismiss her before it expired, then you have to pay her for the period up to the end of the contract. And the long and short of it is the court ordered that she be paid, that her dismissal was unconstitutional, agreed that the contract was subject to the Constitution, and also awarded vindicatory damages for the distress, inconvenience, and breach of our constitutional rights.
Right. But in
So
terms of
her
what we
award, I
discussed,
saw somewhere that it was referred to as $40,000. It would amount to over $120,000 or thereabouts.
so in terms of what we're discussing tonight, theoretically at least, the state could appeal that, or is there no right of appeal?
No, the state can appeal.
The state could appeal. So
Well,
either party.
yes. Yeah,
And
either
appeal.
party, in any matter, generally, either party could appeal. But, and as you say that with
Criminal
appeal, then
matters,
I'm just,
it used to be different before in criminal matters. Not so?
right, but the state can appeal criminal matters too now.
I think that has changed a bit.
Yes, that's changed for criminal
So
matters.
and that matter could go all the way to the Privy Council theoretically.
Theoretically, yes.
Okay.
But I just wanted to say, and that's why, again, the important role of lawyers to guide clients, not because there's an appellate system. I just say, because there's an appellate system, you appeal.
Okay.
You must have good grounds for an appeal.
Mhm.
And especially in civil matters, because it will just end up paying costs and all of these things. And interest, especially when there's a money judgment.
Mhm.
What happens if you just
Right.
appeal for appealing's sake, and you know you don't have a good grounds of appeal, and the Court of Appeal is unlikely to reverse the decision? What happens? So let's say you are appealing against a judgment, given no, or let's given in 2020 for $100,000, and you appeal it, and the Court of Appeal eventually rules on that matter, and let's say 5 years, for whatever reason, passes. It means that the interest on that judgment continues to go up.
Be 30% in 5 years.
Yes, over a period of time. So
Yes.
I'm just saying that to say that there is an appellate system, but you must have good grounds for appealing, or else, you don't appeal.
Yeah. So, Ruggles, before we take any final words, I just want to thank you for coming tonight, and just to say that we will continue this discussion next week. And this time we'll be looking at it from the standpoint of the consumers and typical complaints of people, consumers, litigants, and people who have matters in the court, and people who try to access the court system. The typical ones being delays, costs, and the inability to enforce their judgments. You get a judgment from the court and they just can't enforce it. So we'll continue that discussion next week. Jackie,
Okay.
Christian, and thank you.
Yes. Well, thank you, and thank you, viewers and listeners. Especially love to Jomo and Jackie, and others. I recognize a few names, including Jason, on the program. Yes. So thank you, and no problem. We can complete it next week.
Okay, that's
yes.
great.
Thanks.
Okay.
Good. Bye-bye.